Hello, so my name is Ingrid Vandenborre. I'm a partner at Skadden. I will not be speaking on behalf of the firm Skadden or any of our clients. I've instead been asked to present the perspective of the European Generics Association today in this debate, which I'm very happy to do. And I'm very happy to do that because I think that the perspectives that different participants in this debate have are frankly very much aligned, both from the originator side and the generic side, and even from the consumer side, even though they're not sitting at the settlement table. I think there's a great benefit in permitting flexibility in settling. I'll talk a little bit about the EGA, and then I'll go through sort of the perspective of that there's really no legal basis to limit flexibility in settling, that there's also no economic basis to do that, and that there's a lot of policy implications that may negatively affect generic entry once we impede flexibility of settling. So a little about the EGA. EGA combines a number of generic products companies. The objectives of the EGA are basically to find the right balance between IP, innovation, and competition, increase patient access to generic medicine, sustainable healthcare, and create a globally competitive and sustainable generic medicines industry in Europe. Just a little bit of numbers-wise of the importance of generic medicines in Europe and in the world. And notably, what was put kind of centrally is one of the most competitive sectors in Europe. So, what should be the criteria for reviewing patent settlements? What should be the legal framework? How should we analyze it? It was mentioned earlier today that patent settlements are at the intersection between IP and competition law. So one way they should not be assessed is as market sharing agreements or as cartel agreements. To do that would basically render non-existent any IP law. If you would look at it as a market sharing case, you're basically avoiding the need to discuss any of the IP rights that are at issue. Well, a patent right actually confers a legal monopoly on a company, and with that the right to exclude others. That may not just be important for the company who owns the patent, but also for the generic company who needs to take that patent into account in formalizing its strategies and its legal position and how to act. So when a settlement agreement goes beyond the scope of the patent or somehow is fraudulently obtained or is a reflection of an abuse of a patent system, there is of course every basis for reviewing that patent settlement agreement and for assessing it. But when the settlement agreement remains within the scope of the patent, that is something that a generic company has to take into account. It's a barrier to entry. All competition lawyers would be familiar with that, or competition law students. It's a barrier to entry, and a generic company has to take into account that there's a legal right to exclude it from the market. If that presumption is not applied, if there's no attention being given to the fact that there is that barrier, you immediately resort into analyzing whether the patent settlement agreement was good or bad based on the patent rights that were involved, whether the strength of the patent was sufficient, whether it was a weak or strong patent, and what you then end up doing is assessing after the fact the outcome of a litigation which that settlement was exactly meant to avoid. So you're basically trying to assess whether the patent would have been upheld, whether it would have been denied, and guess what? Weak patents also get upheld, and strong patents also get called invalid. It's very difficult to assess in advance what the outcome of litigation is going to be. And so to undermine the sort of predictability and the ability of generic companies to rely on patents as a barrier that they need to take into account and settle on or not settle on whatever their assessment is very disruptive and imposes obligations that I'll talk about a little bit later, but that cause some serious policy questions. So I talked a little about patents presumed to be valid. So this is sort of to explain a little bit and support why limiting the options to settle really has no basis in law. I know a couple of cases were mentioned earlier today, but those cases really only go to whether settlement agreement should be outside the boundaries of the law completely, which of course no one is really saying here. What we're saying is that there's settled case law that indicates that patents are presumed to be valid, they're assumed to be lawful, and that they they result in a legal right to keep competitors away. That there's a public regulation that requires others to respect that right. That right is not subject to a win in litigation. That right is not subject to being confirmed in litigation or says that litigation is better than settlement. It just says exactly that. It says that patents are presumed to be lawful. There's also no discussion of whether that's only applicable for patents that are weak or patents that are strong, and who would determine whether a patent is weak or strong. That is only determined in litigation, which we're trying to avoid. So it creates a very circular argument to say, well, if there's a weak patent, all of a sudden your settlement is not as supported, is not as good as if you have a strong patent. There's also no legal basis for distinguishing between a compound and a process patent. I think we somehow hear that as well. A process patent is something that is a lot weaker, and so it's somehow more problematic to settle on a process patent than it is on a compound patent. There's also, and this creates sort of a much bigger issue, there's also no basis to really distinguish the pharmaceutical industry from any other industry. What's going to be the limitation on saying that there are boundaries to settling? If that's true in the pharma area, why would it not apply to any other area? The IP area, are we going to start limiting the ability for companies to settle and exit from litigation? Is litigation sort of the end goal that we're trying to achieve, or are we trying to actually have a goal that's different aside from litigation? There's also really no economic basis to limit the flexibility to settle. The value transfer does not imply that there's a weak patent. We talked about weak and strong a lot. It's a very subjective concept. It can ultimately only be determined at the end of sometimes a very long patent litigation. And it certainly can't be identified just by means of assessing the amount of value being transferred to a generic company. In fact, a value transfer may sometimes be necessary to arrive at a settlement position, to arrive at a compromise that facilitates entry. And that's sort of the policy point that I'll drive to at the end. That's why it should not be surprising that we make this point. It's the ability to settle that allows generic companies to facilitate generic entry and enter in advance of patent expiration. Not after, not at the end, not shortly before the end, but much in advance of patent expiration. That happens largely through settlement. So why could a value transfer be necessary? Because there might be a lot of votes or thoughts that say, well, we don't need a value transfer, you just settle. Why don't you just settle? Why do you need to pay money? Why does a generic company need to have any money to engage in a settlement? Well, that happens because the value of a day of sales for originator company and for generic company is very, very different. For an originator company, 1 day of sales represents a huge or bigger amount of revenue because it's monopoly rents. It's the only company on the market. It may be the last day or some key day of being the only one on the market with that drug. For a generic company, typically it means it is one of many companies that have that drug on the market, and the price of that drug at that moment is lower. So the mere reference to a time period doesn't reflect a common viewpoint. It doesn't reflect a common value for an originator or a generic company. So just picking a date in time is not enough to reach agreement, oftentimes, because that day means something very different on both sides of the table. So you need something to bridge the gap. You need something else to arrive at a position that can be common and that can, with the ultimate goal, facilitate generic entry, get the generic drug earlier on the market than if there would have been litigation or if they would have waited till the end of the patent expiration date. I've made one note that there's a difference with the US. There's no first to file rule. We've heard a lot about Hatch-Waxman today already. So it's relevant here because we need to bear in mind in Europe there is no one single generic company on the market. It's not this one generic company that you need to settle with. There might be a number of different generic companies on the market that are all ready to launch, and so it's very unclear what implications may be of bringing a drug on the market at the point or having to settle. So what are the policy implications of limiting the ability or the flexibility to settle? I know the viewpoint is that companies can always settle, we're not restricting the ability to settle, but what does it mean to limit flexibility in settling? It's called Payfordelay. The question, of course, is in the term, what does it mean to delay? Delay beyond what? Is there a counterfactual? Is there a date that can be determined that absent the payment, there would have been entry? There's no such thing, of course, because the litigation doesn't take place, so you can't really determine when the date would have been, that otherwise it would have been entry. Actually, it's the settlement that facilitates the entry. Settlements are important because generic companies can and sometimes do lose in a patent litigation. The whole Payfordelay debate and the whole discussion here and reference to the delay somehow assumes that the generic company will win. At some point they will win. They will get onto the market and the settlement is just delaying that. That's often not the reality. Oftentimes generic companies lose in the litigation and the settlement allows them to avoid that litigation and sometimes enables them to come onto the market and bring the generic drug there where otherwise it would not have been. Even if there's litigation, even if a generic company may win in litigation, that litigation can take years. It can take a lot of costs, a lot of litigation costs to bring that drug onto the market. There's also a point that was mentioned before. Litigation often extends to different member states. So there could be an outcome where a generic is able to enter, wins litigation, able to enter in one member state, is not able to enter in a number of other member states. It's a very diverse picture across the EU. It doesn't allow them to enter. And a generic company has to make a decision as to which member states will be important, which member states will be driving the decision. In some smaller member states, it may not be worth litigating, so you don't bring the product to market at all. If there's no ability to, for example, settle European-wide and make sure you can enter European-wide, generic companies may not want to litigate in every single member state. Small member states would have less generic drugs, for example. Settlements can very importantly avoid a launch at risk. We've heard many times reference being made to why don't you just litigate? Why do you have to settle? Why don't you just litigate? It's better to litigate. Competition means that you have to litigate. But litigation can oftentimes, as I said, result in delay or cost. And if you don't litigate and you just launch, you can have a lot of damage risk. There was a case just in June 2013, around the time frame when these decisions were being issued. Teva and Son settled damages litigation with Pfizer for a payment of $2.15 billion. So there is a cost to just launching and not settling. There is a significant cost. And that cost will come to consumers ultimately because it means somehow in the pocket of a generic company, an assessment has to be made and somewhere something's losing, right? Somewhere a drug is then not being brought to market because an assessment is being made in the portfolio of where that money has to come from. The US tamoxifen case is also a good example. I have to click this again. Okay. So in the tamoxifen case, kind of interesting, there were a number of generic companies that wanted to launch or ready to launch. Some of them chose to settle and others chose to litigate. Those companies that chose to settle were able to enter much earlier with their generic drug than those who chose to litigate. Actually, some lost in the litigation. So there is no clear direction to say litigation is better, litigation is what should take place, and settlement, even if there's a payment, even if there's some payment, will be better for consumers because in this case we had generics actually come earlier to market. And so kind of the last point, which is not the least important, it conserves a lot of resources not to have to litigate in courts. I think we hear that very often as a public policy point of view that settlements are encouraged and litigation is not encouraged. This is what I think think we would support from that perspective as well. I think the whole debate suggests that a generic company should really take the risk and either launch a risk or litigate. And I think there's a perception that it's not actually a big risk. It's actually a kind of a Russian roulette game. When you take into account the value figures, the damage risk that was on the slide before, say you have a Russian roulette game, typical, I hope no one plays it, game with a gun in a barrel, few bullets, you turn around. What if your chances are 1 in 10% that, or 10%, 20%, 30% that bullet is right there in the barrel when you're ready to take your turn? How high do the chances have to be? When will the analysis be, well, this was a weak enough patent, your chances were sufficiently low that you should have taken that shot and risk pulling that trigger, because we assess, as an outsider, we assess that you should have taken that risk. When the risk might be 2.15 billion US dollars, that's a Russian roulette type of game for any generic company to take. And I think the sort of thought they want to put on the table is, why would you not permit flexibility in allowing settlements to take place if the alternative is a Russian roulette game that no one really knows the outcome of, because it's prejudging the outcome of some hypothetical litigation. There's really no basis in law for generic companies to have to litigate, but that's actually what this debate and this decision-making is indicating should be the case, or is the case. We would argue that competition law should not make it more difficult for generic companies to exit litigation and settle. Oftentimes, having a settlement with a value transfer is the only way to exit litigation. Litigation with huge cost, huge delay risks, and there should be means, or more means, and more flexibility for generic companies to exit that litigation. They may actually impact generic entry, I mentioned earlier, by not enabling generic companies to do that, because it may drive them to reassess which products they should bring to market, which ones they shouldn't, where to bring it to market, small member states, big member states, what products carry a lot of risk, not a lot of risk. If I'm not sure I'm able to exit litigation when I want to do that, because an originator may not accept a settlement without some type of value transfer, or we may just not arrive at a common position, should I really bank on wanting to try to launch that particular drug? I'll just refocus my attention as a generic company and focus on another drug. Ultimately, there's a significant risk of slowing down generic entry, which is not the goal we submit that the Commission was seeking to achieve, coming out of the sector inquiry and in all the sort of policy statements. The generic companies are saying that there's a risk that this position and this decisions will risk limiting generic entry. Got it, yes. I think I'm at the end. Thank you.